Hello, everyone. My name is Arif Jamal. I'm the Deputy Director of the Center for Asian Legal Studies, or CALS, at the National University of Singapore's Faculty of Law, and co-convener along with my colleague and partner in crime, Dr. Dian Shah, who you will meet shortly, of the CALS Law and Religion Cluster. The Law and Religion Cluster is interested in issues around religious law, state-religion relations, the regulation of religion and religious freedom, and tries to embrace a contextual and multidisciplinary approach to understanding the dynamics between law and religion. The cluster organizes a series of activities, including the Law and Religion Speaker Series, which you are participating in today. The series would ordinarily be held in person, but we're very grateful to have Professors Jeff Redding and Matthew Nelson, and all of you here with us today for this virtual speaker series session. Thank you, Jeff. Thank you, Matthew, and welcome to you all on behalf of CALS and the cluster. With that, let me hand over to Dian Shah, who is moderating today's session, for the proper introductions. Dian.
Hi, everyone. I am Dian Shah, Arif's partner in crime, and today we have a transnational crime network involving Matthew Nelson and Jeff Redding as well. So I'm glad to be hosting or moderating this event today, which is based on Jeff's book, A Secular Need, Islamic Law and State Governance in Contemporary India. So as you know, we have the author here today, Professor Jeff Redding, who will provide some of his thoughts on the book, followed by commentary or critique by Professor Matt Nelson. So Professor Jeff Redding is a senior research fellow at the Melbourne Law School. He teaches and researches in the areas of comparative law and religion, Islamic law and sexuality. And then we have Professor Matt Nelson, who is an associate professor at the Asia Institute, also from the University of Melbourne. And his research interests span the areas of politics, law, and Islam, with a specific focus on South Asia. Professor Matt was previously with the School of Oriental and African Studies in London. So Matt and Jeff, pleased to have you with us today. And Jeff, over to you.
Okay, great. So before anything, I first want to thank the Center for Asian Legal Studies for this invitation to speak about my book today. CALS and the National University of Singapore Faculty of Law were also generous hosts for me back in December 2018 as I was finishing up a near final version of this manuscript. In addition, Arif Jamal has generously commented on the book recently in an online forum hosted by the Law and Other Things blog. So today's invitation from Dian feels almost like coming home to Singapore. Thank you to CALS, Dian, Arif, Jacqueline, and also Finna Wong for skillfully managing all the complicated cross-border logistics here. In the next several minutes, I want to do three things. First, I want to explore the genesis of the intellectual framework motivating a secular need. Second, I want to summarize the argument underpinning each of the different chapters of the book. And third, I want to explain how I see secular need playing out in some of the current crises stalking India. So first of all, genesis. I first began researching this book way back in 2005 and 2006 when I was working in Mumbai with Lawyers Collective, with the well-known Indian legal NGO run by Indra Jaising and Anand Grover. Lawyers Collective has recently been shuttered by the BJP government in Delhi, and Indira and Anand have also been personally harassed and threatened by the same government. However, when it was operating, Lawyers Collective was very well known both nationally and internationally for working on a wide range of difficult yet important legal matters relating to law, gender, and religion. While I was working with Lawyers Collective 15 years ago, a storm started to grow in the Indian media concerning the alleged rape and divorce of an Indian Muslim woman in the northern Indian state of Uttar Pradesh. Responding to what became known as Imran's case, an Indian lawyer by the name of Mr. Vishwa Lochan Madan then filed a public interest piece of litigation in the Supreme Court of India, demanding that the Supreme Court shut down all non-state Muslim dispute resolution in India, including not only the kind of fatwa giving that led to Imran's divorce, but also Muslim dispute resolution bodies known as Darul Qazas, or more colloquially as Muslim courts, or sometimes as Sharia courts. This litigation and the situations which preceded and followed in its wake are the subject of chapter 2 of my book. In the course of delving into this litigation, including interviewing different Muslim lawyers and activists about it, as well as the lawyer, Mr. Madan, who had initially brought the case to the Supreme Court, I became acutely aware of many Muslims' fears in discussing the case. It was also evident to me that this fear was a consequence of an already very high level of anti-Muslim sentiment existing in India 15 years ago, and Muslim worries that this litigation over fatwas and darul qazas could trigger an even more cataclysmic situation. As a legal researcher, this fear made it difficult for me to gather opinions and legal materials. As a result of these difficulties, and also because any researcher of Muslim life in India cannot but be confronted by it, the Islamophobia being encouraged from so many quarters, both governmental and non-governmental, because this kind of Islamophobia is just unavoidable, I ultimately decided that I had to address this anti-Muslim sentiment head-on in my book, and especially in the introduction. In doing so, I took inspiration from Irfan Ahmed's honesty about the fraught conditions surrounding the ethnographic work he did for his 2009 book, Islamism and Democracy in India, The Transformation of Jamaat Islami. In my own book, in the process of addressing the grave situation in India, I've tried to puzzle through what I perceive to be two competing trends in anti-Muslim sentiment in contemporary secular India. One which bends towards radical exclusion and otherizing, what I call secular hate, and the other towards radical inclusion, what I call secular love. Examining these two paradoxically coexisting secular emotions, my book asks, where else does one find love-hate relationships? One answer that my book explores is in situations of dependency, hence a secular need. Let me now turn to the actual argument of the book and how it plays out across the different chapters. In doing so, let me emphasize that the secular state's dependencies I diagnose are both historical and contemporary, ideological and material. Let me quickly preview 4 different dimensions of this diverse secular need. First, Indian secularism needs non-state Islamic law and legal institutions because of a fear that the secularism may otherwise not be genuine in its tolerance. Historical dimensions of this kind of need get discussed in chapter 1 and more contemporary dimensions in chapter 4. Second, Indian secularism needs non-state Islamic legal providers because of the secularism's ambivalent attachment to feminism. Put succinctly, for reasons of both internal and external legitimacy, Indian secularism needs women, and especially Muslim women, to have robust divorce options. However, state courts in India are themselves unwilling to provide these divorce options. The Muslim court network focused on in my book can and does perform divorces for Muslim women. In fact, data provided in chapter 1 suggests that nearly 60% of the cases handled by the Darul Qaza network are divorce cases initiated by women. Third, Indian secularism needs non-state Islamic legal actors and institutions to intervene with disputing parties where the Indian state cannot because of the state's alien secular qualities, and simultaneously the state's fundamental anxieties and worries about its own illegitimacy. This argument is developed mostly in chapter 5 of the book. Finally, the secular state needs Islamic legal actors and institutions to provide legal services because of how the Indian state is consumed by overwhelming caseloads. These non-state actors, legal actors, help disperse dispute resolution across a broader range of capable legal actors. This dysfunction of the secular state's system of law is evident in nearly all of the chapters of the book. Chapter by chapter, the introduction to my book first traces the secular Indian state's implication in anti-Muslim violence in streets, civil society, and courtrooms alike, while setting up the larger secular hate, love, need argument of the rest of the book. Chapter 1 provides data and case studies concerning the historical and contemporary operations of non-state Muslim legal actors in India, demonstrating the important role that non-state Muslim institutions played in India's independence movement, and then too in the current moment. Chapter 2 traces a crisis point reached in 2005 when Mr. Madan's petition was filed in the Supreme Court of India, seeking to shut down Darul Qazas for the first time in almost a century. This chapter also describes the ambivalent need for these non-state courts that the Supreme Court announced in 2014 when it resolved this litigation. Chapter 3 uses a detailed case study of a Muslim woman's use of a non-state Muslim court to obtain a divorce from her husband in order to illustrate that it is not just reactionaries who have targeted Muslims using legal technologies, but that liberals and liberal rule of law theory has done so too. Building on earlier chapters, this chapter also argues that hatred of the non-state by allies of the secular state elides the secular state's dependence on the Muslim non-state. Chapter 4 explores the dynamics surrounding divorce, which undergird India's secularism's need for Muslim courts, tracing these divorce needs across domestic, regional, particularly in relation to Pakistan, and global domains. Chapter 5 again returns to a detailed case study, this time of a Hindu plaintiff in a Muslim court litigating a property dispute this time that the Hindu plaintiff had with the Muslim defendant in this case. In the course of exploring the extended and multi-sided litigation between these religiously diverse parties, this chapter demonstrates the secular state's fundamental legitimacy gaps and the ways in which Muslim courts help fill some of these gaps. Finally, the conclusion wraps the book up with an extended plea for us to understand the affective economy and emotional registers of secularism, and also the emotional pathologies that secular states too often fall into. Secular statecraft in India is a feeling project. There is so much feeling here. As a result, the conclusion urges the reader to bring complex tools of analysis to bear on this kind of affect-laden governance and the pathologies it is riven with. With regards to these pathologies, and concluding my remarks today, let me mention that this book was researched and written over several years. Like any author, I was worried that events might outrace the book and that our project begun in the midst of 2005's Imran crisis might not be relevant to 2020 and beyond. I'm happy, but also very sad to report that my book is still very timely. Indeed, the widespread Islamophobia that has unfortunately distinguished Indian governance for the past many decades and the dependencies it reveals are both accelerating and accumulating. In my book's conclusion, I look to the future of secular Muslim relations in India. I'm certainly not optimistic in this conclusion, but I am also not completely despairing. That being said, this conclusion was written shortly before the bifurcation and dissolving of the Muslim majority state of Kashmir, and also the anti-Muslim mob killings that happened in Delhi at the beginning of 2020, just a year ago, and the even more recent blaming of Muslims for spreading COVID-19 in India through their so-called irresponsible religious gatherings. In all these developments, the accusation that Muslims are disease spreaders is especially troubling, and the most indicative that India is yet again on the verge of genocide. The echoes here of how Jews were characterized by anti-Semites in Nazi Germany are impossible to not hear. If I can still offer something, however, that is not just short of complete despair, let me simply observe that COVID-19 has offered up a quick and deadly rebuke to macho states invested in their alleged potency. That an enemy like a virus can be so vigorous yet so invisible is a humbling lesson for these kinds of states, India included. Moreover, that the state needs the widespread cooperation of its citizens to end this plague, including severely marginalized citizens who have little reason to be invested in the state, has got to be enraging for these states. Put another way, it is not surprising that secular India under COVID-19 continues to be a hateful state, a loving state, and moreover, a very needful state. Even more ominous, however, have been the recent efforts to render tens of millions of Indian Muslims stateless using the twin technologies of the National Register of Citizens, or the NRC, and the Citizenship Amendment Act, or the CAA. To me, this effort is where secular need potentially falters, where secular hate has become secular rage. For it is difficult for a state to need people that it does not even see as legitimate people. That being said, the future of this eradication campaign is highly uncertain, even if presently frightening and soul-destroying for the people directly affected by it. My book, part of a global South Asia book series, emphasizes that Indian law and politics must be understood to be in deep conversation with regional and global events. And regional and global pressures are likely to push back against what will surely be a regional and global disaster if India's Muslims are rendered stateless. To conclude then with the final words of my book, the challenge is thus, as I see it, quote, secular need does not have to culminate in secular rage. Rather, there might be a less destructive path through the complicated predicaments and paradoxes that histories, Islamic and otherwise, have laid out for the contemporary secular state, even if there is no way out, While this path is uncertain, the place to begin involves a deep reckoning with the feeling state, which is at its heart, a hateful state, a loving state, and a needful state. I'll end there. Thank you.
Thank you very much, Jeff, for a very concise yet informative introduction to your book. Before I go to Matt, I just want to remind all our attendees that if you have any questions for Jeff or subsequently for Matt, you can use the Q&A box at the bottom, and I will then post or repost the questions rather to our two speakers. All right, Matt, over to you.
Great. Okay. Thank you very much, Dian. And thank you to Jacqueline and Arif and everyone for inviting me. And of course, thank you, Jeff, for this extremely interesting, engaging, and enriching book. I've prepared some fairly detailed comments. So like Jeff, I hope you won't mind if I just sort of read through them and then we'll open things up for questions, or I suspect that some of you will be posing questions in the Q&A box along the way as well. So to start, I just want to mention one of my recent students, a fellow by the name of Guy Eyre. It's E-Y-R-E, Eyre. And he wrote his PhD thesis about the ways in which various Muslim groups in Morocco look at one another, okay, as both Muslim kin and simultaneously across these Muslim groups as competitors, both allies and antagonists, okay, both friends and foes. Okay, and these are different groups of Muslims. Well, in Guy's thesis, he found a certain measure of theoretical inspiration, interestingly, in the mid-19th century work of an American author and poet named Ralph Waldo Emerson. Specifically, Emerson's ideas about the ways in which others, he was writing about friends as others, the ways in which those others help to define one's self. For Emerson, Guy noted, a quote, friend was both close and far, okay, an object of attraction and also difference, someone associated with generosity, but also jealousy. And I'm quoting, "Let him be to thee forever a sort of beautiful enemy," Emerson wrote, "untamable, yet revered." Okay, when I read Jeff's book about different perspectives regarding these non-state Darul Qazas or Muslim courts in India, on the one hand, different perspectives with Indian Muslims who visit the Darul Qazas to resolve their disputes. And on the other hand, Indians who criticize the Darul Qazas, mostly in Jeff's book, Indian secularists, and then Hindu nationalists with a rather ironic sense of Hindu toleration. This sense built both on the work of Congress leader Mohandas Gandhi and on the RSS ideologue M.S. Golwalkar, which is a notion that Hinduism can transcend and ultimately subsume all religions. Well, when I read Jeff's book, I was reminded of Guy's PhD thesis. Basically, Guy's intertwined Muslims in Morocco, both allies and antagonists. They looked a lot like those debating Jeff's Darul Qazas in India. Critics, if you will, who just can't look away. Okay, critics, but still drawn in. In Jeff's book, Indian secularists and Hindu nationalists fear, but simultaneously desire or need a single undifferentiated Muslim other. Specifically, Muslim others associated with these non-state Darul Qazas, these Muslim courts. Of course, Jeff points to a background filled with diverse Muslim views and patterns of engagement vis-a-vis these Darul Qazas. So on the one hand, Jeff describes Sunni Deobandi Darul Qazas, the focus of the book, and at the same time, he points to Sunni Deobandi, sort of a political party known as the Jamiat Ulama-e-Hind, which has a group of institutions known as the Mahakama al-Sharia, or the Sharia departments. And then he turns to Sunni Barelvis with their Idara-e-Sharia, or Sharia organizations. And then he mentions the Shia with their own Sharia courts. And then he mentions the Jamaat-e-Islami another important political party, with what they call Shariat panchayats, and on and on. So different Muslims, different non-state Sharia centers. Okay, well, some of those who have commented on Jeff's book have complained that the book fails to disaggregate the views unfold within India's diverse Muslim community, a Muslim community that's disaggregated by caste or by class or by biradri or these kinship groups or by languages or by sects and so on. Okay, but in my view, actually Jeff doesn't fail to disaggregate Indian Muslims. What he does is he acknowledges certain forms of intra-Muslim difference, and then he focuses on Muslims who engage just one feature, just one specific feature of India's complex law landscape. And he stresses in particular gendered forms of difference within that particular part of the landscape. Now, it is true that many who don't visit India's Darul Qazas, but instead criticize their work, many of those who criticize their work do fail to articulate a complex or disaggregated understanding of Islam or the Islamic legal tradition. They stereotype, they homogenize, and so on. Indeed, even the really basic argument that was reiterated by Talal Asad, namely the argument that historically Muslim and non-Muslim ideas, including lots of different ideas about secularism, these ideas have bumped into one another, they've interpenetrated one another, and they have constantly reshaped one another. Even this rather basic argument about the constant interaction of Islamic and secular ideas, this idea is often ignored by many people. Those who Jeff calls the partisans of secularism in India, who have a fairly undifferentiated idea about Islam. But in my view, those failures to appreciate this internal diversity in Islam, they're not Jeff's failures. On the contrary, I think Jeff just illuminates the debates and then the political implications that grow out of these types of oversimplified views regarding informal Muslim dispute resolution in India. What happens when people think about Muslims or Islam in an undifferentiated way? They think about an other that they can fear or be drawn to. Okay, well, by and large, I think Jeff's examination of India's Darul Qazas and those who criticize them is bound up with a study of what might be described as secular state psychology. Okay, focusing specifically on one sphere of Indian state secularism, the legal sphere. Now, as you probably know, there are lots of scholars out there writing about the psychology of states these days. So at SOAS, where I've spent years and years, one colleague writing about Africa writes about Africa through the psychoanalytical lenses of a psychoanalyst named Melanie Klein. This scholar is Julia Gallagher. Well, to be honest, I often struggle with some of the wild speculations and theoretical leaps that emerge in some of this work about the psychology of states. Fortunately, Jeff himself acknowledges that it's one thing to describe states with existential fears of a dangerous other. Okay. Now, this is, of course, the bread and butter of international relations theories regarding state security. If you can't talk about states that fear another, how can you write about international security? But then Jeff adds, we need something else to rely on notions of existential fear in a way that allows us to assess a complex psychology of state emotions. Okay, not just a simple emotion, fear, but a complex psychology of love and hate and fear and desire. Okay, as if states, their various branches, their complex bureaucracies, their multidimensional publics, were all somehow brought together and driven by an identifiable collective unconscious. That's a bigger leap. Okay, nevertheless, building on the work of Thomas Blom-Hansen at Stanford, who uses the work of psychoanalyst Jacques Lacan to examine Hindu nationalist psychologies in Bombay, basically psychologies that, according to Hansen, led Marathi-speaking Shiv Sena Hindu nationalist activists to then replicate or mimic the supposedly hyper-masculine qualities of their Muslim targets, if you will, their alter egos. Jeff takes us on a journey to what might be described as a legal psychology of Indian state secularism, its loves, its hates, its needs. Briefly, to give you a sense of how this works, Jacques Lacan and then Thomas Blum Hansen focus on the ways in which actors are drawn towards what they lack, okay? And for Jeff, India's Darul Qazas fill up certain gaps, okay? They satisfy certain needs in the context of Indian secularism. They satisfy things that are missing, okay? So Indian secularists, for instance, find that the existence of Darul Qazas makes it possible for these secularists to claim that Indian secularism protects religious minorities, because there they are, the Darul Qazas. We protect them, we allow them. In fact, without Darul Qazas, Jeff argues that Indian secularism would effectively lack this rhetorical option to describe its protective powers. As such, Darul Qazas satisfy a particular ideological or rhetorical need. Okay, similarly, for Hindu nationalists, the existence of Darul Qazas makes it possible to describe a type of Hinduism that subsumes all religions and religious minorities, as in some sense, the meta expression of toleration. Okay, so without Darul Qazas, Jeff argues, Hindu nationalists would lack an ability to make this claim. In effect, their ideological self-understanding as tolerant would suddenly be taken over by a description of them as intolerant fascists. So Jeff argues that Darul Qazas fill up both ideological and material gaps. They satisfy needs. So without Darul Qazas to provide the divorces that Indian state courts are notoriously involved in delaying or avoiding, Indian secularists and Hindu nationalists, they didn't have the Darul Qazas, they would find it difficult to position themselves as defenders of Indian Muslim women who need divorces. And on a material level, Jeff basically tells us that without non-state Darul Qazas to handle thousands of divorce cases, India's secular state would just lack an ability to manage its caseload. Okay, all of this is very clever, innovative, psycho-social legal argument about the satisfaction of secularism's ideological and material needs. But I think one of the challenges that emerges in Jeff's work concerns the identity of the actors who need the Darul Qazas to fill up what they lack. Now, in Jeff's account, the actors who need the Darul Qazas are the Indian state, Indian secularists, and Hindu nationalists who style themselves as secularists because they see Hinduism as subsuming all religions. But in the course of his ethnography, which is excellent, Jeff clarifies that many Indian Muslim women also need Darul Qazas. It's not just the secularists and the Hindu nationalists. The Muslim women need the Darul Qazas, mostly because they're trying to avoid state courts that don't give them divorces. Or they need the Darul Qaza because it provides them with a fesla that they can ask the state court to endorse, or they're just trying to avoid the state courts altogether and get a divorce in a community forum that might be considered legitimate. Well, in Jeff's book, these Darul Qazas perform quite a lot of ideological, material, and emotional work for the state, but they also do a lot of work for Muslim communities and Muslim women. Who needs these courts? It would be interesting to know how Jeff sees the psychosocial, psychopolitical, and psychoaffective role of India's Darul Qazas vis-a-vis Muslim needs. What is the lack that India's Darul Qazas fill up for Muslims? Is it a lack of authority for India's male ulama? Is it a lack of power for India's Muslim women? Is it both? Okay, Jeff's book is called A Secular Need, but in the future, maybe a different focus like a Muslim need will also reinforce his story. Okay, I'm gonna shift gears a little bit here. In the book, Jeff takes up this relationship between Islam, Islamic non-state legal practices, and secularism in India. Okay, this relationship between secularism and Islam, or between secularism and any other religious tradition, this can never be reduced to an either-or question, a question about the relative power of secularism or religion, all right? These questions I find unhelpful. A generation of scholars have taught us that secularism itself is a space of religion-state relations. So secularism, by definition, needs religion. Okay, so analytically, the relationship between this or that form of secularism and this or that understanding of religion always unfolds a bit like a Venn diagram, right? A Venn diagram with two circles that overlap. There are overlapping parts and there are non-overlapping parts. Okay. So seems perspective, phrases like Islamic secularism can make a certain amount of sense, okay, because they point to what the great Mughal prince Dara Shikoh famously called the mingling of two oceans. Okay, the mingling of two oceans, the secular ocean, the Islamic ocean. Okay, now bear with me, I'm going to tell a little story. I recently visited the south coast of Tasmania here in Australia, where part of the Southern Ocean begins. Okay, now it's true that the boundary between two oceans is often rather indistinct or blurry, but it was equally obvious that as we rounded the last little tip of Tasmania to join the Southern Ocean, with no further land between our little boat and Antarctica, there was a certain boundary in the ocean. The water itself did not change, okay, but the waves around us, suddenly so much more intense, they did change. In short, the key signifier didn't change. We were still just sailing on water, okay? But the grammar and the idioms created by that water, still just water, it changed. Okay, now in his account of mingling oceans, okay, the Islamic Ocean and the secular ocean, if you will, Dara Shikoh did not describe the unity of the ocean, right? And even today, scholars rarely focus on singular forms of words like law or modernity, or for that matter, Islam or secularism. We examine multiple modernities, forms of law, okay, interpretations of Islam, and comparative secularisms, okay? And we speak of historically situated patterns of translation between these oceans, interaction between Islam and secularism. Now, I think Jeff's book tells us a lot about comparative laws, comparative secularisms, and the tension-ridden psychology of interacting traditions. When you encounter that other ocean, there's friction, there's attraction, there's concern and fear, and you just can't look away. Now, if I remember correctly, Talal Asad taught us that Islam is a discursive tradition. Okay. He also taught us years later that the histories of Islam and secularism are mutually constructed. They're tightly imbricated. Each helps to fashion and construct the other. But to my knowledge, Talal Asad did not teach us that Islam and secularism were one and the same thing. He did not discuss the unity of one all-encompassing religious ocean, including Islam. He did not teach us about the nature of secularism itself. Instead, he just tried to highlight the challenges and, like Jeff, the politics of religious and secular encounters, tensions in all of their complexity. Now, some scholars continue to write as if there is just one real domain of Islamic law, calling that domain, at least rhetorically, as a counter-universal to something called secular law. Okay. Sometimes, while Halak's comparison of early and later ideas about Islamic and state law, I think it's misread as a story of contrasting universals, right? The Islamic law of the early Islamic period and state law today, two different universals. Now, I think binary readings like this are generally misleading or unhelpful. The realm of Islamic law was early on and remains still today multidimensional, dynamic, and contested. And the realm of secular law is similar. Indian secularism, American secularism, contested articulations of French secularism today, anyone? Each with internal variations, disjunctures, and conflicts. So my point is just within each part of this Venn diagram between secularism and Islam, various bits are always mingling, the mingling of the two oceans, not unlike the waters of a religious and a secular ocean. So to wrap up, a few sentences. Jeff's book advances our understanding of one rather important legal location where fragile boundaries of law contested boundaries of what is religion, Islam in this case, and the rather anxious boundaries of secularism are eliminated. And when I finished the book, I felt I had a much deeper understanding of contemporary legal debates located at these boundaries in India. And I also felt I had a much better understanding of where these Darul Qazas at least used to fit, intersecting gaps of two very large legal oceans, where these Darul Qazas fit as a friend, if you will, simultaneously untamable and revered, just like Emerson said. And one question, as Jeff points out, concerns the degree to which the secular need that these Darul Qazas used to fill up will remain in India for much longer.
Excellent. Thank you, Jeff and Mike, for your, sorry, Matt. Who was Mike? Thank you, Jeff and Matt, for your insights on the book and for offering us much food for thought. And also thank you for all of you for participating in this webinar. We will be having a few more webinars on law and religion throughout the rest of the year. So please keep an eye out for our emails, and we look forward to engaging with you again soon. Thank you.